Good morning, and thank you for joining us for today's online talk, which will be starting shortly at 11 a.m. For those of you who are early, thank you for waiting patiently. And while you are waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website, and we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everyone. Thank you for joining us for today's online talk which is entitled Retrenchment During the Covid-19 Pandemic. My name is John Chan, and I'm a Senior Associate with Mao Wing Kwai & Associates, and I will be your moderator for today's session. Now, before we start today's talk, let me introduce the firm and what we do. Mao Wing Kwai & Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing Kwai. Our able team today comprises 22 lawyers and a support team of 19. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small medium enterprises, SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Please visit our website at maowinkrai.com for more information, to read our articles, and to sign up for more upcoming talks. Next, allow me to introduce our speakers for today. Firstly, we have Janessa. She's a senior associate in our dispute resolution and employment departments. She graduated from was admitted to the Malaysian Bar in 2014. She's a certified mediator with the Bar Council Mediation Center. And her practice areas include corporate and commercial litigation, employment, reviewing and drafting employment contracts and policies. Next, we have Janessa. She's our associate in our dispute resolution, employment, and individuals and families departments. Graduated from the University of Liverpool, was admitted to the Malaysian Bar in 2017, and her practice areas include employment, industrial relations, advisory, and litigation matters, debt recovery, adoption, probate, and administration of estates. Now for our Q&A later on, we will be doing it by Slido. If you have any questions, please don't forget to post it up on Slido, and we will address them at the end. Our top points for today will include these: employers' rights and obligations, options available to employers, what is retrenchment, retrenchment process, and justifying the retrenchment decision. Handing over to you, Diana.
Good morning, everyone. Thank you for signing up this online talk. Today, Janessa and I will be sharing our views on one of the most widely discussed topics among employers during this COVID-19 pandemic, that is retrenchment. The first phase of the Movement Control Order, or we call it as the MCO, was implemented since the 18th of March till the 31st of March. We are currently in the second phase of MCO, which is implemented from the 1st of April, and it will be ending soon on the 14th of April. So last Friday, our Prime Minister announced the extension of the MCO, which is the third phase of the MCO, which will be starting on the 15th of April and till the 28th of April. Our Prime Minister further indicated that if the situation doesn't improve during the third phase of MCO, it may be further extended. During this period of MCO, we have heard employers and business owners express their concern regarding the challenges and difficulties faced by them. So as a business cannot operate as usual, business owners and employers face difficulties face financial difficulties. So they face a decrease in revenue, loss of income, cash flow problems, and on top of that, employers and business owners have to fulfill their employment obligations as well. We heard business owners and employers express their difficulties in paying their employees wages or salaries, and at the same time they have to also fulfill their obligations to pay rental or loan repayments. We also have employers and business owners who express a concern or face difficulties or challenges with regards to employees' disciplinary problems. So there was a case referred to us where this particular employer faced employee disciplinary problems, where employees were instructed to report to work but failed to report to work, or employees who are instructed to work from home chose not to do so, or ignored emails, calls, or scheduled virtual meetings by the employers. So as an employer, what are your rights and obligations during the period of MCO? As an employer, you have the right to instruct your employees to work from the office premises if you fall under the essential services industry. And if you are a non-essential services, if you fall under the non-essential services industry, you have to obtain approval from the relevant authorities before you can instruct your employees to work on site or from the office premises. Regardless whether you are in the essential services or non-essential services, you may instruct your employees to work from home. If you face disciplinary issues among employees, as an employer, you may take disciplinary action against your employees. So, what are your obligations during the MCO? So during this period of time, you, as an employer, you have to pay full wages and applicable allowances to your employees. And if employees are required to work on site or from the office premises, you have to comply with the COVID-19 preventive measures at workplace. And this can be found in the guidelines issued by the Ministry of Human Resources and the Ministry of Industrial Trade and Industry. We have heard many employers ask what are the options available to them during this period of MCO if they face financial difficulties. On one hand, to sustain their businesses, and on the other hand, to fulfill their employment obligations. So these are the options that are available to employers. First, as an employer, you may reduce hours of work. You may cease new recruitment of employees, limit or reduce overtime, freeze bonuses and increment of salaries, offer early retirement to employees who are near retirement age. You may exercise temporary layoff. Of course, this must be done with consent of the employees. You may offer partially paid leave or unpaid leave with the consent of the employees. You may exercise pay cut, and however, if you exercise pay cut, it must be done with the mutual agreement from the employee. If you manage to obtain agreement or consent from the employee, we advise that you record such agreement or consent in writing. So the following two cases are cases which discuss on pay cut. And we find that these cases are useful, hence we would like to share with the audience out there. In the case of Lim Ban Leong and Goldbridge Engineering and Construction Berhad, this case stress on the communication, the importance of communication to maintain industrial harmony. In this case, the industrial court opined that traditionally any salary cut to an employee's pay can be used as ground by the employee to plead constructive dismissal. However, if the company is facing losses and is trying to fight off closure of its business or retrenchment of its employees, the company can appeal to the employees to ride through the rough time with it and take a salary cut, which can then be reinstated and increase when the business picks up again. The industrial court further notes that there should have been much more engagement by the company with its employees in order to maintain industrial harmony. So the court actually stressed on communication between employers and employees with regards if the employer wants to exercise pay cut in order to maintain industrial harmony. Peanuts Realty Sriram Berhad and Chi Yu Kong is another industrial court case which talks about pay cut. And this happened during the economic downturn in 1997. So in this case, the industrial court took cognizance of the economic downturn in 1997, and the industrial court also took note that the construction industry was badly affected. The court found that the company had to adopt a proactive stand to create a win-win situation for the company and the employees. Now, this is interesting. The court finds that the reduction of salary of the claimant and the other relevant employees was done in good faith and justified in view of the financial situation of the respondent company and the predicament it is in, and that it was intended to be a win-win for both the employees and the respondent instead of retrenching the employees or dismissing them. So in this case, the court actually recognized that salary cut was done correctly, or it was justified in view of the financial situation of the company, and the court thinks that the salary cut was done in good faith. The last two options that are available to employers are also the voluntary separation scheme and the mutual separation scheme. The voluntary separation scheme is often referred to as an alternative to a retrenchment exercise. So employers must be wondering, can I carry out retrenchment exercise? The answer is generally yes, provided that you have exhausted all the available cost-cutting measures and options that we have recommended earlier just now. And the retrenchment is subject to guidelines and fulfillment of legal requirements, which my colleague Janessa later will explain in depth. I will briefly explain what is retrenchment by referring to decided cases, and Janessa will explain on the retrenchment procedure, the legal requirement and guidelines to be followed by employers in the event employers decide to exercise retrenchment. So what is retrenchment? In the often quoted case of William Jacks and Company, Malaysia Srember Hart and S. Balasingham, the Court of Appeal defined retrenchment as a discharge of surplus labor or staff by an employer for any reason whatsoever, otherwise than as a punishment inflicted by way of disciplinary action. So in this case, essentially, the court acknowledged that a company has the managerial prerogative to reorganize its business, but the managerial prerogative is not absolute. If the facts show that the managerial prerogative was not done in good faith, or was not carried out in good faith, or amounts to an unfair labor practice, or indicates victimization, then the court will not hesitate to rule that such retrenchment exercise is bad. In the case of Ong Gi Leong and others, and Lim Kim Hai, Electric Malaysia Srember Hart, the court says that before there can be a retrenchment or termination of the surplus, there must be redundancy or surplus of labor. Who bears the burden of proof in proving redundancy? The Court of Appeal in Bayer Malaysia Srember Hart and Eng Hong Pao held that the burden of proof falls on the employer. So employer has the burden of proof to prove that the retrenchment exercise was carried out in good faith and it was genuine. The case of Aluminium Company of Malaysia Berhad and Jaspal Singh, in this case, the industrial court held that in the law of redundancy, it is important to note that it is the services of the employee which must be made redundant and not his position or his title. Retrenchment of an employee can be justified if carried out for profitability, economy, or convenience of the employer's business. Services of an employee may well become surplus if there was reduction, diminution, or cessation of the type of work the employee was performing. So this was discussed in the case of Cooperative Perkhidmatan Angkatan Tentera Berhad and Mayor Othman Lutfi bin Abdul Latif. So Janessa will be explaining on the retrenchment process. Over to you, Janessa.
Thanks, Diana. Okay, to those of you who just joined us, or if you missed the introduction session earlier, I'm Janessa, and I'll take over from here to further discuss the retrenchment process before we move on to the Q&A session. So just to briefly recap, Diana explained earlier the challenges faced by employers during the MCO period, the options available, as well as the definition of retrenchment. So as highlighted by Diana earlier, in a retrenchment case, it is the employer's duty to prove redundancy. Surplus of labor is frequently the first or the main situation that the employer would generally notice or identify. So I've listed 3 examples here on what would amount to a surplus of labor. So in a reorganization or restructuring due to financial stress, or a situation where there is a consolidation of departments, in situations where employees job and workload can be taken over by other employees, all these would amount to a surplus of labor. Moving on to the next slide, these are the few things that the Industrial Court would generally take into account. The Employment Act 1955, the Industrial Court will have to look at whether or not the selected employees or the retrenched employees fall within the ambit of the Employment Act. The Industrial Court will also take into account the Code of Conduct for Industrial Harmony to determine whether or not the guidelines stated in this code were observed by the company. Just like other dismissal cases, in the event your employee is of the view, or in the event your employee considers himself unfairly dismissed during the retrenchment process, the employee may make a representation to the Industrial Relations Department pursuant to Section 20 of the Industrial Relations Act. When the matter is referred to the Industrial Court, or if the matter is being referred to the Industrial Court, the Industrial Court will then, or the Industrial Court may look at decided cases when determining or deciding on the merits of your particular case. Some of you may now ask, what is the Code of Conduct for Industrial Harmony? So very briefly, the Code of Conduct for Industrial Harmony primarily aims to promote fair and systematic practices, and it also sets out the principles and guidelines to be observed. This is mainly to achieve greater industrial harmony. The Industrial Court would usually refer to this Code of Conduct when the court has to determine whether or not the retrenchment process or whether or not the employer's actions throughout the retrenchment process were reasonable. In my next slide here, I've plucked out 3 main examples in the Code of Conduct for the purpose of today's talk. So under Article 20 of the Code, it is stated that consultation with the employees' representatives or their trade union must take place. Positive steps to minimize reductions of workforce and appropriate measures ought to be observed by the employer. So what are these positive steps and appropriate measures? Diana mentioned earlier, so I won't discuss that right now. Long story short, under Article 20 of the Code, it basically says that retrenchment should always be the last resort. Moving on to Article 21, the Code of Conduct and the Industrial Court generally recognizes, acknowledges, and respects the fact that it is the company's prerogative in deciding or determining how a retrenchment or how their business should be carried out. However, Article 21 further states that consultation must be observed at all material times. As for Article 23, priority for engagement or re-engagement should be given to the retrenched employees. For instance, if this particular job scope subsequently or in the near future becomes vacant, or when hiring is required for that specific job position, Article 23 of the Code states that the priority should be given to the retrenched employees before other new employees can be hired. The next question would then be whether or not non-compliance of the Code of Conduct is fatal. If the company does not observe or does not comply with the Code of Conduct, would it be detrimental to the company's position in the event the matter is being referred to the industrial court? Or is this Code of Conduct a mere guideline? The quick answer to this question would be no. It would not be fatal, nor would it be detrimental to the company's case. In this case of Equan Integration Services Sdn Bhd, the court held that the Code of Conduct is a mere guideline, and failure to consult the employee or failure to observe and comply with the Code of Conduct would not automatically render the retrenchment process as bad faith. But I think it is important to highlight the fact that the industrial court is a court of equity. The court will have the right and power to observe the Code of Conduct strictly. The closest we can refer to, or the closest we can rely on to say that the Code of Conduct has a degree of legal bearing would be Section 30 sub 5A of the Industrial Relations Act. Under this particular section of the Industrial Relations Act, it is clearly stated that the court may take into consideration any agreement or code relating to employment practices. So the term code here would generally refer to the Code of Conduct of Industrial Harmony. So with or without the Code of Conduct, whether or not the court or the company observe the Code of Conduct, there are other key issues that the industrial court will pay attention to. So number one, the court will have to look at whether or not there was a severe cutback in business volume. And in the event the court is convinced that there was a severe cutback, the court will then look at whether or not it leads to a reorganization. Whether or not it leads to a reorganization, the court will also look at whether the business has been downsized. So how do we determine whether or not your business has been downsized? In the event your production line or business unit unfortunately has to be discontinued, it would almost naturally or automatically bring you to a situation where you will have surplus of employees. And very naturally, when an organization has surplus of employees, it would give rise to a redundancy situation. From this case of Arjit Singh Gurbachan Singh, the court held that mere evidence of reorganization would not be sufficient. In other words, the employer or the company must be able to establish concrete evidence to establish redundancy or to prove that the company had acted in good faith throughout the retrenchment process to ensure that the company did not have any motive of victimization. In short, it is essential to establish that this particular employee who was selected during the retrenchment process, that employee's job position or job scope reduced tremendously to be deemed redundant. So now that it is established that the employee is redundant, what would be the next step for the company? The next step would be the retrenchment process. It is very important for the company to ensure that the retrenchment process taken by the company is proper, fair, and just. How do we ensure that the process is carried out fairly? This is a general overview of how a retrenchment process ought to be carried out. Point number one is to establish genuine redundancy, which I pointed out a while ago. Point number two is to consult trade union. Do take note that this would only be relevant or applicable to organizations or companies that are unionized. If your organization is a unionized organization, there would definitely be a collective agreement. It is important to make sure that the terms and conditions stated in the collective agreement are observed and complied with during the retrenchment process. And every collective agreement's terms and conditions would vary. Point number 3 would be to consider terminating foreign employees first. Section 60N of the Employment Act specifically states that in a retrenchment process or in a retrenchment exercise, if your organization has foreign employees, these foreign employees must be identified and retrenched before your local employees are selected. Point number 3 would be to observe the guidelines provided for under the Code of Conduct for Industrial Harmony. Moving on to point number 5 would be the last in, first out principle. And I'll discuss this LIFO principle shortly. After all these steps have been observed, the company will then have to submit a statutory form, also known as the Borang PK, to the nearest Department of Labor. Article 22A of the Code of Conduct lays down the measures to be taken in a retrenchment exercise. Point number 1 is to give early warning or notice to the affected employees. You may now ask me, why do we need to give early notice? So to give early notice, apart from establishing good faith on the company's part, it is also to enable these affected employees to seek alternative job. Point number 2 would be to introduce schemes, and schemes would be voluntary separation scheme or the mutual separation scheme, which were mentioned by Diana a while ago as well. Should your organization have employees who have reached the retirement age or past the statutory retirement age, in a retrenchment exercise, these employees should be identified first. Article 22A of the Code of Conduct also states that the company should assist employees to source for alternative employments. Point number 5 states that companies should try to spread the termination of employment over a longer period. A longer period would generally refer to, for instance, the employment contract may state that the termination period, notice period will be 3 months. If it is well within the ability of the company in terms of the financial aspect, perhaps the company can consider extending the period to 4 months or 5 months. On top of enabling the employee to source for alternative jobs during the extended duration, it would also assist the employees in the financial aspect. In the event the matter goes to the industrial court, the employer can point out the fact that the employer had taken all necessary measures, unfortunately have to retrench the employees, but even during the retrenchment process, the company tried their level best to extend the period and to extend the period in order to assist the employee in the financial aspect and to provide them a longer duration to seek for other jobs. Point number 6 is mainly to ensure that the news pertaining to the retrenchment does not reach the employees' ears before the company speaks to them directly and personally. The code also provides, under Article 22B of the Code of Conduct, that employers should select employees to be retrenched in accordance with this objective criteria. So number 1, is it really necessary to retrench the employees to ensure that the operation is efficient? If the answer to this question is yes, during the process of retrenchment, the company has to take into account the ability, experience, skill, and occupational qualifications of these employees. The company should also look into or take into consideration the length of service, the status, the employee's age or family situation, and other criteria. Moving on would be the last in, first out principle. Very briefly, the last in, first out principle literally means the last employee to join the organization or the company should always be the first employee to be identified in a retrenchment process. In the case of Dynacraft Industries Sdn Bhd, the court held that where an employee's years of service from a previous organization is acknowledged by the employer, the said period of employment has to be taken into consideration. Let me give you an example for this. If your company has subsidiary company A and subsidiary company B, and the employee was transferred from A to B, there would generally be a new employment contract. In this new employment contract, if there is a specific clause to state that the employee's years of service in subsidiary A will be taken into account in subsidiary B, the entire duration of the employment of this particular employee's employment from subsidiary A to subsidiary B must be taken into account by the company during the last in, first out principles consideration. It then brings us to the next question. If the company does not comply with the LIFO principle, would it be fatal? As you can see in these two cases that I've listed in my slide, the answer is no, it would not be fatal, or rather it may not necessarily be fatal. Failure to comply or failure to observe the last in, first out principle would not automatically render the retrenchment mala fide. It would not automatically bring to show that the redundancy of the particular employee is not genuine. The courts have acknowledged that there will always be situations where a departure from the LIFO principle would be necessary, and this would vary on a case-to-case basis. In this case of Sarawak Shell Berhad, the company in this particular case did not actually follow the LIFO principle. The company came up with their own comprehensive selection criteria process. No surprise, the retrenchment process was being challenged in the industrial court. Upon looking at the merits of the case, the court held that the company had taken all necessary steps to ensure that this special comprehensive selection criteria created by the company complied or is in accordance with the law. And the court also held that the company had every reason, had strong and valid reason for departing from the LIFO principle. So how do we justify the retrenchment decision made by the company? As we all know, when a matter is being referred to court, apart from key witnesses, the main and the best evidence to produce in court would be documentary evidence. This is mainly why we would always advise our clients to put everything into writing. So what are the documents that would be essential in a retrenchment case? Financial reports. Financial reports would be necessary to convince the industrial court that at the time the retrenchment process was carried out, or at the time the company was of the view that the employee's position is redundant, for example, the company's financial standing was very weak. As such, the company was unable to continue paying the employee's salary. Apart from financial reports, other documents to prove that sufficient communication was made, or documentation to prove town hall notices, negotiation process, or any discussion pertaining to voluntary or mutual separation schemes would be essential as well. Proof of other cost-cutting measures. I believe my colleague Diana discussed about other measures to be observed by the company. before a retrenchment process ought to be carried out. Proper documentation of all these other measures would be very important as well. Pre and post reorganization charts. This is mainly to show the court that a retrenchment exercise was in fact or is in fact necessary. A comparison will be made side by side for this pre and post reorganization chart to show that there was in fact a downsizing. In my next slide, I've listed a few general tips for proper paper trail. Detailed notes, minutes of meeting, or other form of correspondence. We always advise our clients to use simple language and straightforward words. This is mainly to prevent any form of ambiguity, and it is also to prevent the possibility of wide terms being used in your documents, which may open to debates in terms of the interpretation of the words. It is also important to avoid using hostile statements in your documents. You wouldn't want a situation where when you go to court and your document is actually very important and it bears a lot of weight for the company's case. But because of certain statements made in, for example, the show cause letter or the warning letter, it ends up being self-incriminating. So it is important to avoid such statements in your document. It is also important to always have an acknowledgement copy of the employee receiving whatever documents, be it show cause letter or warning letter or even termination letter. Label your documents accurately. Keep them in an organized chronological manner. It is also always important to have a scanned copy or an online version. So this is to prevent you from losing your documents entirely in the event the physical copy goes missing. All right, I believe this is the end of my session. I will hand it back to our moderator, John, for the Q&A session. John, all yours. Thank you everyone for listening.
Thank you, Janessa. Right, next we will go straight to our Q&A session. Which will be done on Slido. Right. Just a reminder for those who are not on this page, you can scan the QR code or you can join at slido.com and key in the hashtag number 39574. All right, we'll take the first question at the top. Can a company use poor performance as a reason to retrench the employees during the MCO? Diana, would you like
Yes,
question?
Thank you, John. The short answer here is no, because for poor performance, you have a different set of guidelines or legal requirements that you have to fulfill. And it is not the same as the legal requirements and guidelines for retrenchment.
Thank you. Right, next. Can employers force their employees to take paid annual leave? Diana or Janessa, anyone?
Okay, I can answer this question. So, can employers force their employees to take paid annual leave? The answer is no, unless, of course, you can get the employees to consent. And if the employees do consent to take paid annual leave, it is important to have it in writing.
Thank you. Next question. If the company intends to shut down one of the business outlets due to reduced turnover aggravated during MCO, can the company retrench all employees? I'm assuming retrench all employees. Janessa?
The answer would be yes. The company can retrench the employees provided the process that I was discussing earlier and the other measures to be observed, which was mentioned by Diana during her session. If all these are observed and complied with, then I don't see an issue for the company to retrench the employees.
Right. This is a question. If my business is under essential services, but my employees refuse to come to office, what can I do? This is a question which we've seen a few times already, even in the chat box. Maybe Diana, you can answer this.
Okay. If my business is under essential services, but my employees refuse to come to office, what can I do? So in this situation, we will view such a situation as a employee misconduct, or you can also say that failure to report to work without permission of the employer. This is equal to absenteeism. So if you have such a situation, you should first issue a show cause letter to your employee, and then the usual disciplinary procedure will apply. So after issuing a show cause letter, if you're not satisfied with the explanation given by your employee, or you think that the reason given by your employee is not valid, then you may issue a warning letter. This should be treated as a misconduct on the employee's part.
Right. Just to add on a bit to Diana, case law has said that absenteeism of more than 2 or 3 days is serious misconduct. So in terms of disciplinary procedures, it's up to the employer what it wants to do. If it finds the explanation by the employees not satisfactory, it can give a warning letter, it can cut pay for that period of time. It can also go all the way to termination, because case law has said that termination is justified for absenteeism. All right, next question. What is meant with consent from employee? If employee not consent, can employer take action, as they will not give you any choice and will offer early retirement? Janessa, you want to answer this?
Yeah, sure. What's the question? Okay, if I remember correctly, I guess the question means whether or not we can force the employee to be retired if the employee does not consent to the company's request. So this depends on the particular employee's employment contract, number one, and number two, whether or not the employee has reached the statutory retirement age. After reading the employee's employment contract, and if the employee has reached the statutory retirement age, if the contract provides that termination is allowed, then yes, you may, but I don't believe such clause to be contained in the employment contract. It is still important for sufficient communication to be made, and it is still important for the employee to consent. If retrenchment is necessary and pursuant to the code of conduct, employees who are soon to be retired should be identified first, then I guess your company will just have to follow the process, have proper documents, and be able to prove the necessary elements. Then it shouldn't be a problem as well.
Yeah, to add on to that, right, this was discussed in the case of Pinus Realty. So in that case, right, the claimant alleged that he was dismissed because he refused to sign a consent letter for a salary reduction of 25%. And the claimant also claimed that he was forced to sign a resignation letter or an option for early retirement. So in that case, the court says that if the company was really in a financial difficulty, and the company and the court in that case recognized the effort made by the company in seeking a win-win situation between the employer and the employee, and the company had no choice but to exercise a pay cut. So in such extreme circumstances, the court may decide that the retrenchment is genuine if the employer is going that has no choice but to exercise retrenchment. Yeah.
All right, thanks, Diana. Next question, must I return or pay back my employees their deducted salary after the MCO if they already agreed to the pay cut?
I'll take that question.
Okay.
Yeah. If during the negotiation between the employer and employee, that if as an employer, if you agree or promise your employee that if you agree on a pay cut now, and I will reimburse the deducted salary later when time gets better, then yes, you will have to reimburse later. But then if you did not give such a promise to your employee, then I think under the law, you are not obliged to do that.
Thank you. Next, can a company use pay factor as consideration to retrench an employee? Example, higher pay staff will be priority to retrench. Janessa, I think you can answer this.
Yep, sure. Pay factors consideration, higher pay. Generally, the company would have to identify which particular department incurs the most cost. And if the company is of the view that the higher pay employees adds burden to their financial standing, then yes, they can be prioritized in a retrenchment process, or they may be prioritized in a retrenchment process. But again, I have to repeat that the process discussed earlier and the other factors to be taken into account, as well as the elements to satisfy in a retrenchment process, must be complied with.
Right, so you're saying the LIFO principle still outweighs this higher pay stuff, would you say?
I would say yes.
Next, if the company is operating at 50% capacity, can we agree with employees to reduce working hours and prorate salaries? Diana?
Thank you, John. If the company is operating at 50% capacity, can we agree with employees to reduce working hours and prorate salaries? Well, if you manage to get an agreement or consent from your employee to reduce working hours, why not? Yeah, there is no hard and fast rule. As long as you communicate with your employee and your employee is agreeable to reduce working hours, yes, you may do that.
Thank you. The next question, I think I can summarize it as how does retrenchment apply, or the retrenchment principles which you all have explained earlier, does it apply to workers on fixed term contracts as well? Janessa?
The process discussed earlier applies across the board, but I think this question actually means whether or not if the employee are contract workers. I think they're referring to contractors. If they are contractors, then they are not an employee or an employee per se. So yes, the Contract Act will apply in the civil court instead of the industrial court. That's if I get the question right.
I see. So you're talking if it's a contract for service instead of an employment contract of service.
Yes, that's what I understand from the question.
But if it's a contract of service and it's a fixed term contract, then the retrenchment principles would still apply, right?
Yes, it will.
Right. Thank you. Right, this one. Need more clarification on actions an employer can take when staff refuse to come to work during the MCO for essential services. Diana, maybe you can list the possible actions again.
Yes, this was answered earlier, I think, in the first two questions. As an employer, what can you do when your staff refuse to come to work during the MCO, especially for employees under the essential services? So, as I said earlier, the usual disciplinary procedure would apply. As an employer, you can issue a show cause letter to your employee, and your employee will have to respond to the show cause letter. And if you find your employee's explanation is not up to satisfaction, you may issue a warning letter, or you may exercise a pay cut. Or in extreme circumstances, absenteeism may also lead to termination of employment.
Next question. If an employer has followed the retrenchment process, does it still need to compensate the employees which are retrenched? Example, 1 month salary equals for each year of service.
I can take a question. Yeah. So this would depend on the particular employee's employment contract. If the employment contract does not state that retrenchment benefit is mandatory, then the company can actually refuse to pay. But of course, it is a good industrial practice to compensate to provide retrenchment benefit. And the usual compensation scheme would be 1 month salary per year of service.
Yeah, but I understand there are also cases where compensation was not paid because the company was really in a bad financial situation. So it couldn't even pay the notice period under the letter.
So the company will have to be able to establish that their financial standing does not enable them to provide such retrenchment benefit.
Yeah, right. Next one. If we choose to do a pay cut now, how do we communicate with our employees? Can we just issue a letter, or do we have to wait until the MCO is lifted? Diana?
Okay. I think the key here is communication. So communication can be done by way of email, can be done by way of telephone calls, can be done by way of virtual meetings. So as long as the company's financial situation or financial standing is communicated to the employees, and consent is obtained from the employee to exercise pay cut, the company can have until the FDA. You have to, as an employer, you have to record such consent in writing. This is to protect yourself.
Okay. We're running a bit short on time, so we'll take the next 3 questions. Right. 2 departments with same functions but different clientele. Can I retrench the least performing department, the whole of the department that's not making revenue? Janessa?
Okay. I think the person asking this question will first have to identify whether this is a poor performance issue or a loss of revenue issue. So if it is a poor performance issue, then it is a separate, there are separate legal requirements to comply with. But if the company can identify or can prove that this particular department is not making any revenue, again, if you have the necessary financial reports and you comply with the process and stuff like that, yes, you can close down this particular department during the retrenchment process.
Thank you. Right. Next one, for unconfirmed staff, 6 months working with us, do we have to follow the retrenchment process? Will it affect my government subsidy application for staff salary? Diana, maybe you can answer this.
I think this goes back to Janessa's presentation earlier, that I think the LIFO principle would apply here. So the unconfirmed staff, unfortunately, he or she has to go first if you follow the LIFO guideline.
See, but will it affect the subsidy?
It will not affect the subsidy application for staff salary as long as you fall within the requirements under the wage subsidy program.
I see, okay. All right, last one. Few of my employees are currently under probation, less than 2 months. Can we dismiss them? I think this is a general, I'm not sure whether this is a general dismissal or on retrenchment. Maybe you can answer on both situations, both you and Diana. Janessa.
So if an employee is under probation period, you will first have to identify whether or not the probationary period has come to an end. So if the probationary period has yet to come to an end, then no, you cannot just terminate them. You cannot just dismiss them, because when an employee is placed under a probationary period, it is for the company to assess their performance. So during the MCO period, if the company is unable to assess their performance, the company will have no basis to say that they failed to pass the probationary period. So the quick answer to this is no, you cannot just dismiss them like that. Let's see if Diana has anything to add.
Yes, so you will have to see whether the employee who is under probation period, whether he or she is not performing, or his performance is not up to satisfaction, or whether he has committed a misconduct. So for poor performance and misconduct, there are two different sets of guidelines and rules that would apply.
Right. Okay, maybe we take one more question, last one. Sorry, where is it? I saw earlier I clicked the question over. The question was, what is the minimum majority that the employer must get before it can implement, for example, paid leave? So what's the minimum majority of employees?
Sorry, John, can you repeat the question?
Yep, so the question was, what is the minimum majority of employees' agreement that the employer must get before it can implement, so to say, forced paid leave?
I see. I think it is the company's decision if it is if the company has discussed with the employees and they consent to it. It's good to put into writing, but if you have a certain number of employees who do not agree to it, but if the company is able to show the company's financial standing and the company's inability to pay, then to some extent the company has no choice but to compel the employees, then that is possible as well.
I see. Right.
Yes,
thank you.
So there is no law or regulations that are imposed on the employer on what is the minimum number of people that should consent to a pay cut or unpaid leave. So it all depends on communication and negotiation.
All right, thank you, Diana and Janessa, for your insights.
Thank you.
Before we conclude, I have a few announcements to make. Firstly, please join us again for our upcoming talks. On the 15th of April, we have a talk with the title Discussion on Force Majeure and Frustration of Contract in Sale and Purchase Agreements. On the 17th of April, we have the title Citizenship for Adopted Children and Stateless Individuals. And on the 20th of April, we have the talk on Wills and Administration of Estates. To sign up, you can scan the QR code or go to our website. I'll just leave it here for 10 seconds. Secondly, please fill up our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat box. Thirdly, please do follow or like our social media accounts. The link to these accounts will also be posted in our chat box. If you would like to speak with one of our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill up the form in our website or the link, or you can click on the link posted to the chat box. And to all our guests today, thank you for joining us. We hope you have found today's session informative and useful.